Okay, hi everybody. How you doing? Hi. Y'all are on here. Y'all make me so nervous when you guys come on here and I know don't come over here with the negative energy cuz I know you're not talking about 2 minutes after the day that I had and I'm 2 minutes late. And y'all not going to give me no grace. And I'm always on time. Hi everybody. So, y'all, we got so much to talk about. We about to get into it for real, for real. I got one of my new favorite people. I got a lot of favorite people, but this one of my new favorite people. But I have a feeling she's gonna be one of my favorite people forever. And we are about to get into it, okay, guys? So I'm gonna just go ahead and get started. We got Miss Jefferson here. Everybody say hi to Miss Jefferson.
Hi
You
guys.
have moderators on here? Because I feel like I might need some moderators tonight.
Oh yeah, definitely.
Let
I'm
me see who I
sure.
got that's moderating. Hi, everybody. We're about to really
Nice
get
to
into it. I
you.
got so much to tell y'all.
Oh, I can't wait. First day back. First
First
day back.
day back. Back outside. We back outside. How that song go?
Was that we outside tonight? That's my one.
Okay.
I love that one.
I gotta let me go to YouTube on from my profile and see if I can add some moderators because normally I got my mods on here to add mods. Hold on. See, and I got people texting me right now about filing a complaint against the person who was messing with me today because he messed with. Let me tell y'all,
Mess with the wrong one. We gonna get
I
into
don't
it.
understand why people haven't learned a lesson about messing with me because I feel like it comes to a point where you would have learned your lesson. That okay, hold on. Let me add some moderators. I'm sorry. Miss Jefferson, can you get us started off with some opinions while I get some moderators going and while I get some clips going? Tell me about how you feel about today, girl.
I want to fight. I don't condone violence, you two, but I want to fight. I want to fight. I just like meet me on the steps at 3 o'clock. Like I was today years old when I figured out that we can hold you till all of YSL is done was a lie. I did not know that was illegal. That they could not hold Woody. Like y'all lied to that man in that room. Mm, 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 mm. I just today was a little bittersweet. I felt the way about the bonds. I felt the way about no bonds. But I'm not gonna say I didn't jump for joy and hit my shin today when love was gathered. That judge gathered love completely on everything that she usually do in about 7 days. Today she managed to do it in about 7 minutes, and the judge caught her every single time. I'm so happy. I'm so happy. Y'all, ooh, I've been waiting for her to get caught. I've been waiting for her to get caught.
Okay, guys. So I'm gonna start at the beginning. So let me see, Green Hearts, if you were a part of Hallway Chronicles. Hallway Chronicles. Let's go. We're gonna start with Hallway Chronicles, and then we're gonna work our way to Miss Love because I feel like what I have to say is more important than I feel like what happened to me today is more important than what happened to Miss Love. I don't know. But y'all always say I'm clout chasing, so I'm gonna just chase off my own name today.
You cloud chasing, but they ain't here on your cloud. Okay.
And they keep saying my name. Okay, guys, so this what happened. The judge was definitely okay. So a lot of you guys have been on with me. I was on for about 4 hours today. Hold on, I still didn't add no moderators. 1 second. Let me add some moderators. I don't got time to play with y'all today. I'm finna add some moderators. Sorry. We got who want to be a moderator? Tika. Okay. Tika, I just added you as a moderator. And I just added Happy as a moderator. Okay, now I'm exiting out. Okay, guys, so I'm here. So today I went to the courthouse and I did not expect for it to be easy breezy. I'm not gonna lie, my anxiety was on 25 on a scale of 1 to 10. And I didn't know who was gonna be looking at me crazy. So the first thing I did was I submitted a Rule 22. And that is what you need in the state of Georgia to be able to bring a recording device in. They prefer 24 hours notice. I submitted mine pretty late. Didn't get a response. No big deal. Stream from Miss Sylvia because Miss Sylvia is the GOAT. Whatever. Cool. Contacted the case manager this morning. No response to my Rule 22. Whatever. Moving on. Okay. So I actually am a practicing lawyer, unlike, other people who could just go in the courtroom and say, I'm not trying to be funny, but I'm saying, so I had Zoom court. So I have other clients. I can't be like, I can't make a hearing because I got to cover the YSL trial. Nobody's trying to hear that. Nobody's trying. I'm going to lose my bar card. So anyway, so I'm like, I'm going to sit out here in the hallway. And now y'all got me thinking that I'm gonna do Hallway Chronicles as like a little subsection because Hallway Chronicles was lit today. I'm telling you, so many people walked by, so much stuff happened in Hallway Chronicles. So I got to start from the beginning. So a lot of y'all, do y'all remember when I kind of got distracted? I was talking to a deputy. So I was talking to this deputy and he just came up to me and he was like, Miss Bumpus, can I serve somebody in the courtroom? Because I have an attorney over here who is saying that I can't serve her client because we're in a courtroom. So I pulled up the statute. I'm like, I'm in the middle of my live. I'm trying to make my own money. I'm on Zoom court. I'm trying to run my YouTube, but I'm still like, okay, and I already feel some kind of way about this person. So we're going to get into that too. But I'm like, I know how to move past things. Okay. I'm moving past it. So I put up the statue. I'm like, yeah, you could serve him. Go serve him. Go serve him. He right there. Go serve him. So then they go serve the man. And no, not in the courtroom. I didn't say in the courtroom. You have to listen. Listening is fundamental. I say in the courthouse. And actually, you can serve someone in the courtroom as long as their hearing is over. You can't serve someone in the middle of a hearing. And so the prime example I use is there's so many times where, and this is exactly what was happening today. I could have called it like a book. There's a criminal case. It could be misdemeanor, felony, where there is a victim. They then get a TPO as a result of this criminal case, and they want this TPO served. The only way they can get this TPO served is at this criminal hearing. Do it all the time. Can't go to them in the middle of the hearing and say, hey, you're served. As soon as they're done, boom. So he came to me, I give him the statute, boom. They walk past me, and this is one of my colleagues who I'm going against, who's saying, don't serve my client, this is illegal, but I know what she's talking ain't right. But I'm just trying to, be in the middle. Once again, I'm staying away from 1C, y'all. I'm telling you, every time I go to 1C, I get into something. Anyway, so they walk past me after they done served the man. The deputies look at me and they say, thank you, counselor. So now the lady know I done told him the law. She know exactly it's me. I'm like, Lord have mercy. But this is all on Hallway Chronicles. It's all on live. If you think I'm lying, go be a part of Replay Gang and you will see it. Long story short, we're going to move on. So I stayed outside the courtroom and then we went on lunch. After lunch, so much had happened. I was mad. I was angry. There was no bond. Another person walked by, Jonathan Melnick. John said, hey to you guys. We said, what's up? I said, John, what you think about this no bond? He said, well, somebody say, I ain't gonna say he say, somebody say, well, I could have told you that because She never reconsiders bonds, and that's just her policy. Her policy is once someone has heard the bond, that she doesn't go against them, whether that's a magistrate judge at first appearance, another judge, she doesn't go against them. Whatever, that's not important. Thank you. Jonathan, he always got the great. We spent the whole day in court yesterday. He's one of the smartest attorneys I know. I call him when if Jonathan says it, it's a few people that I say it's the law. If Jonathan say it, it's pretty much the law. Cool, whatever. He also, he just tells me a few things, and he didn't tell me this, guys, but I also know that he has also been called as a witness. So now he's a witness. So all of you guys keep talking about I'm a witness. I have not been called as a witness. I have not been listed on the witness list. There is nothing keeping me from going in this courtroom. Okay. So other than my client on Zoom, an eviction that I just did for my people that work at the nail salon, they do my nails for free. I love getting my nails done. So I do all their business work. They get on my nerves. Did their little eviction, kept me in court all day. That's why I'm in the hallway. So lunch is over. I'm done talking to you guys. I go in the courtroom and I sit down. This same deputy who just asked me for legal advice then comes and says, "You can't sit in here." I'm like, "Huh? I can't sit in here." Now, keep in mind, let's get a transcript or something, because I know my name was said at least 50 times today. Maybe 100. I don't know, but I don't know what makes you think in your right mind that I'm not going to be a party to a proceeding where my name is constantly being brought up, where my livelihood, where my bar card, where my career is being constantly brought up, and my ex-client. So I'm like, okay.
They called your name, okay? They called
Well,
your
they
name.
called a name because Brian called me Bumpkiss. He couldn't get it right. I'm like,
He
Brian,
spelled it and still said it wrong.
but we knew who he was. We knew who he was talking about. We knew who he was talking about. Okay, y'all. So I go and he like, "You're a member of the public." Now keep in mind, I have came and I told you guys I don't follow this trial, but I have come to one seat and sat in that courtroom on multiple occasions. Never have I been made to sign in. Never have I been made to surrender my phone call, my cell phone. I've always been treated like an attorney. They've always recognized me as an attorney, even before Woody. And when Woody was there, definitely recognized me as an attorney. Whatever, neither here nor there. So I'm like, "What you mean?" Like, he caused this big scene, everybody looking at me, all the defendants looking at me. Like, once again, Judge Whitaker just gives this announcement about people walking in and out, being a distraction, all this. And this man is messing with me. Okay, and let's also keep this in mind. This man is one of her normal deputies. So this is his time to shine, baby, okay? He is normally assigned to Judge Whitaker. He knows her. Whatever he says is going to be law. And I don't need any more, I don't need any more judges feeling no type of way about me. I don't need that at this point. So I get up, I walk out, I sign my name on the paper, come sit back in. I still have my cell phone. I'm checking emails. I'm put my phone up, checking emails, whatever, texting, whatever. Nobody says anything to me about my phone. So we go on this 10-minute recess at I think about 3:30. Come back in. They do a little shift. I'm back on my phone. I'm not on social media. I'm not recording. I'm not doing anything. Even though I have a Rule 22 that's unsigned and submitted and try to do everything the right way, but still nothing. And this man yells my name, Bumpus, to the point I ain't even gonna. Thug looks at me. Everybody in the courtroom looks. He says my name so loud. Everybody looks at me. And I'm looking like, what the heck? You can't have your cell phone. Get up and come out. So this is the second time he has come and approached me. Oh, y'all get the likes up. Kiana says 440 people watching, only 74 likes. She's confused. I'm confused too. Get the likes up. So I'm like, okay, what's going on? What's really going on? So I'm like, we're gonna have to call a supervisor. Somebody gonna talk. So he called the supervisor and I had to tell her, she said, "Girl, go sit down, take your phone, go have a seat." But even out of respect, I take my phone back in there, but I just put it in my purse because I'm not on no weird stuff. I don't want to draw attention to me. Anyway, find out later that he tells the supervisor, I'm showing people in the courtroom stuff on my phone. I haven't I haven't talked to nobody. I haven't looked at nobody. Lie. Okay. Needless to say, this is the person who exposed the ex parte hearing. And this is a fact. We was in the ex parte hearing, y'all. And I don't really know him. I don't know a lot of the deputies, but I was in there and he's like, speak to me. He's like, hey, Caleb. Everybody call me Bumpus. Hey, Bumpus. Da, da, da. I'm like, hey, like I seen him before, but I don't really know him. So when the ex parte meeting, like I'm telling you, when we came out of the ex parte meeting, I can't say that I would not have exposed the meeting. I can't say that. And I don't believe that he exposed anything of legal relevance. I think that I did that and I accept that. But Judge Glanville and all of them who think I ran down or text are wrong. It was your deputy, sweetheart. It's the person in your chamber. So let's get it clear. Deputy Brown, the person who put me out the courtroom.
For the family that's in here, I told y'all. Didn't I tell y'all? I told y'all once they start to complain, then y'all get on me. Some of y'all was coming at me on TikTok about them dang on clothes when I said, if they that petty to holler about them clothes, I bet you that's who told Steele. Who bet me? Okay, Deputy Brown. I'm
going to get a picture of him too. I'm going to show y'all who he is. So, and I got so much more to say. So, let's go back to ex parte hearing. We're going to start right there. So, we in that room. He's like the man. He is the deputy who told everybody to turn their body cam off. That's what I'm saying. I'm tired of people playing with me. So, you played with me today. So, now I got to tell the whole world that you are unprofessional. You had no business. You're not a lawyer. You had no duty to tell nobody nothing, Deputy Brown. Just like you had no business messing with me today. So anyway, let's go. So I'm gonna put his picture up there when we go through stuff from the courtroom. I'm gonna say that's him, y'all. That's him, y'all. Okay, so we in the TC, I'm tired of people playing with me. He played with me today, so now he has to get exposed. I've been protecting him for a month and a half. I've been knowing who it was. I haven't said nothing. But at the end of the day, you embarrassed me today. You embarrassed me almost. Really, you embarrassed yourself because, and that's what I told him when I walked out the court. I said, thank you so much for the content, sir. Because I'm going to let you know at the end of the day, I said, I can't wait to get on live about you tonight. So I hope Patrick Labat is watching. I hope that he knows his deputy is the one who went down and told, which I'm glad he did it. Whatever, kudos to him. But at the end of the day, sir. So then we in the meeting, he talked to me, he cool, he was real nice to me. So when everything went left after you got 5 minutes, Brian going to jail, I'm running out of court, that man wouldn't look at me. On the day on the next day after the ex parte, that man would not look at me. His whole energy, his whole vibe completely changed. He would not even look at me. People from the DA's office told me they were in a group chat and they had him as the suspect who leaked the ex parte meeting. Okay, that was number one. I had other deputies tell me who believed it was him, and I had people who knew for a fact it was him tell me that it was him. So I'm going to court tomorrow, and I hope Deputy Brown is there. I'm no shame in my game because, baby, people finna stop bullying me. I'm so tired of people bullying me. Miss Jefferson, what
you gotta turn the camera around so we can wave at him and go, "Hey, sis."
Who, TT?
I'm
oh, Deputy Brown.
Hey, sis. Hey, sis.
I'm gonna make sure my Rule 22 gets signed. This is them boys final part. Look, this is not messy, Gloria. You're wrong. What I'm trying to say is the point of me even saying this is that if deputies and judges treat lawyers like this, imagine what they're doing to regular people who have no voice. So it's not about me being messy. It's about what is your reason for messing with me? What is your reason for bullying with me? I'm sitting in this courtroom, I have no recording going. and I don't have no reason for you to be messing with me, and you just come and pull me out. That's embarrassing to me as an attorney. First of all, the spotlight already on me. Judges already looking at me. Other attorneys already looking at me. Whether it's good or bad, people are already looking at me. And now you are further. And then you allow this man, this judge, to mess with me for weeks when you know what you did.
That's exactly what I was getting ready to say. Was it messy when your career was at stake? Was it messy when your career was at stake? He didn't think it was messy when he went running to Brian Steele. So, and then he let somebody else take the fall for it when he saw it was a big deal. So, no, it's not messy when it's somebody else's career. What was messy was going in here playing. See, what y'all not understanding is those deputies obviously have some sort of sense of entitlement or some sort of authority complex, because if they treat a lawyer like that, how are they treating those people that are in those situations in shackles? That's the messy part. Who can't speak for themselves.
Yes.
They can't speak for themselves. Their attorney may not be there while they're being transported back and forth. The judge may not hear what this deputy is doing, but the deputy think he got some rank in there. So, hey, Deputy Brown.
Hey, Deputy Brown. Like, stop playing with me. And now, I hope that everybody sees this, and that I hope Judge Glanville sees this, and I hope Judge Glanville issues me an apology, because you sat there and told the world she, when it was he, sir.
He blamed you so quick. Oh, he blamed you so quick. Had the little shady boots comments about his dang going. What did he say? We caught you on camera talking to Steele. Glanville.
You did, yeah. After they came, tapped me on the shoulder, I'm already in an anxiety attack, emotional distress from what I've been through for the past 2 hours. Now I got people tapping me on the shoulders, asking me all kind of questions. So that's what happened in Hallway Chronicles.
In the hallway, y'all. That's where the camera needs to be, in the hallway.
Well, that's where I got caught. Remember, I got caught in the hallway at 1:33 p.m. talking to Attorney Steele, Attorney Sharp, and Attorney Weinstein.
He had to say it. Had to say, "Oh, Glanville, you got egg on your face. You got egg on your face." Oh, I'm not. I didn't use it, but I don't know what the bar is gonna do with it. Like, he was being petty.
And the Supreme Court.
You being petty and in the video don't mean nothing. Was probably walking and talking to the dang on deputy the whole time after that.
So Deputy Brown, I'm gonna point him out when we go through, because now we got to get on. It's so much stuff we have to talk about today, guys. It's so much stuff we have to talk about. Okay, so I gotta find this part in the video, but I'm about to find it. I'm gonna put this on the stage. We're just gonna talk about all of this, guys. It's just so much. I gotta find the part where, let me find this part where Brian is talking to.
Thank you, Your Honor.
Let's see. I'm skipping around. I'll come back to other parts.
There has.
I'm trying the case and putting on evidence based upon this so-called self-serving statement. My understanding, Your Honor,
is the part where
that changed with the new evidence. And I cited for the court in my motion that I filed on, Attorney Adams, and I filed on July 10, 2024, some cases, and I might have attached the cases actually to the motion. I can't remember now.
I know this is it, y'all. We had this long look. He says while he's like preparing his stuff for, like, I don't know, maybe 5 minutes, and Judge Whitaker says this is a lot of silence. He say, I hope it's worth it.
Right, but he had to get it together though. But that stuff is from months ago.
Anvil did. I have all objections to any proffer made by District Attorney Love. They are not only wrong.
Fourth time.
But I'm going to show you why they are knowingly wrong. This is the fourth time.
I'm at the right part.
I know you're not here privy to this.
Okay.
What Prosecutor Love did not tell you is the Georgia law that I've already handed to them. Judge Glanville has ruled on this 3 times.
Okay.
Every time telling the state the same thing, that they're wrong. So I'll go through it for the 4th time that Miss Love intentionally, I assume, she has a memory of this because she was here. I handed her all these cases. So I assume that she's doing it intentionally. First of all, what she has told you about the case in your reading of Waddell is not accurate. The original case that the state is using is a case from the 4th Circuit called United States versus Young. Young is what Waddell talks about.
Okay.
If this honorable court would look at United States versus Harry, which should be in your package. I may not have put this in perfect order because one of them were not stapled, but you should have the United States. Okay, and Harry is Harry, and it is 2014 U.S. District Lexus, which is LEXIS 160233. And what happens in the Harry decision is the district court judge in New Mexico analyzed a beautiful analysis of the Young case. And that starts, Your Honor, on page 11 of 17 of the copy I've given the honorable court and the parties. And if you can turn to that page, if you don't mind.
I'm there.
On the left-hand side, the first full paragraph. And it reads, in United States versus Young, which is YOUNG, the 4th Circuit did not explain its decision, but held only that the district court did not abuse its discretion. The holding in United States versus Young may be explained by the fact that the 4th Circuit was applying the previous version of Rule 16, which used the term evidence in chief. Unlike Judge Friedman in United States versus, and I'm just going to spell it if you don't mind, HSIA, the 4th Circuit did not define evidence in chief as case in chief. And then it goes through defining case in chief. The advisory note, I skipped 3 lines, Your Honor. The advisory committee notes to the 2002 amendments state that the change from evidence in chief to case in chief may be substantive in nature. The term evidence in chief may have, as the 4th Circuit held, encompassed both the parties' case in chief as well as a party's non-impeachment cross-examinations. Even if the term evidence in chief encompassed all non-impeachment evidence, including cross-examination, this broad term does not mean that the term case in chief does as well. The 4th Circuit in United States versus Young indicated that a party's case in chief encompasses the time in which the party calls its first witness until it rests by repeatedly using the term case in chief in that manner. So I tell you this because the Waddell case goes back to the Young case. The Young case is a federal analysis of a rule that we don't have in Georgia. In addition to that, there have been 0 circuits following United States versus Young. Georgia has never cited Waddell or Young, but Georgia speaks directly on what our law is. And there's 2 different cases, Your Honor, with the same name of Green, Green. And if you can take a look.
I'm going to fast forward a little bit, y'all.
At the most recent.
In the meantime, Brown is famous now.
Accused obligations under the Discovery Act.
He's famous, guys. We got it going, guys.
Opt into Discovery. And if you look at
Stop
the
playing with me. I'm
copy
sorry
I've given this
playing
honorable
with me.
court and the parties, it starts October 2023. Says it's hard to hear, or whatever her words are.
Maybe what page of the slip opinion?
I'm trying. I think it's page 11.
Y'all
is
gotta
what
watch
I'm looking at.
Adrian, y'all. Y'all gotta watch it.
It starts out with one
Right.
final point.
Mhm.
Okay. So the Waddell case, the judge said, no, you don't have to give it over. But if you're lying, that's, I think, I'm not saying that's
Right.
in the
No, I
opinion.
read it. Yep.
Then you're going to be in a lot of trouble or something
Right.
to that effect. But what happened in the issue in Waddell was they were talking about a statement given to the accused before the indictment. So it wasn't done under the auspices of work product, where the lawyer goes out and interviews witnesses. What Ms. Love tries to do is, I would have a chilling effect. I interviewed every witness that would talk to me. I interviewed everybody. And what Ms. Love is saying is, give me your work product. If I'm not going to use it the way I understand the law, unless you tell me differently, I'm not giving it to the state. So
That's my understanding as well.
So when she says, Mr. White, and I heard what you said, they didn't use it, why would you ever get it? That's exactly right. I hardly cross-examined Mr. White. But the state is telling me to give it. They went so far as Ms. Love called our investigator and tried to get involved and break the attorney camp. She told our investigators, you can call me, give me any recordings that you have of Mr. Bean. Now the investigator's skilled. So he must have said, I wasn't on the phone, but Ms. Love then reported it to Judge Glanville, who said that was appropriate. Doesn't ask him in front when he's here to be cross-examined. They come up with the Judge Glanville ex parte, give him some sort of document that supposedly shows Mr. Bean is scared, which I doubt. This is just me, doubt out of no evidence. And then in the middle of that document says that Brian Steele
Y'all think I'm too far
and his
ahead from when he was
investigator, I'm
doing
not
the hand
quoting,
motion?
were in a car with Mr. Bean and his son.
No, I think it's
And
smart.
Brian Steele was telling Mr. Bean what to say. And his son has that on recording. That never happened.
Yeah, there she goes.
That never happened. But what Ms. Love was allowed to say in front of the jury, believe it or not, did Mr. Steele stop and start that recording? Mr. Bean said what he always says, I don't recall. I objected outrageous. It just flows right through. The same way Ms. Love stands here today and says it's hard to hear, or whatever her words are, hard to decipher on an Apple iPhone.
Look at the eye roll, y'all.
That did not happen. It is offensive. The legal analysis is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong. And this lawyer knows it, because she sat here in court and I did the same thing without being tempered.
All right.
That's 4 times.
Thank you for clarifying that.
Yeah, briefly respond.
Wait, no, I gotta rewind it because y'all gotta see the
Mr.
part
Steele
where
clears
she
the-
says he better not put his hands on me. I think it's right here.
It's a term of art.
It has a distinct meaning.
Yes, and if you go back to the Harry case,
She literally says, because I'm in court and I'm like, and what
it's
you
an
gonna do
enjoyable
if you
case to
do?
read. They go through case in chief versus evidence in chief, and they talk about specifically all the U.S. Supreme Court cases.
Look at Simone.
It's on page 8 of 17 of United States versus Harry, Your Honor. It's well written. It's really a good job. On the left-hand side, the first full paragraph on page 8 of 17. And the district court in New Mexico wrote Courts have repeatedly used the term
Definitely
case
said
in
I don't
chief
talk
to
to her.
refer to the
Gotta go
part
back to that part.
of the trial between the time that a party calls its first witness and when it rests. And then they go through all these United States Supreme Court cases that talk about that. I mean, it's not even an issue.
Hey, but we might as well just listen through it, because at this point, we'll go past the silence.
Original case that the state is using is a case from the Fourth Circuit called United States versus Young. Young is what Waddell talks about.
Okay.
If the Honorable Court will look at United States versus Harry, which should be in your package. I may not have put this in perfect order because one of them were not stapled, but you should have the United
got
States. Okay, and Harry is Harry, and it is 2014 U.S. District Lexus, which is LEXIS 160233. And what happens in the Harry decision is the district court judge in New Mexico analyzed a beautiful analysis of the Young case. And that starts, Your Honor, on page 11 of 17 of the copy I've given the Honorable Court and the parties.
He killed me shaking that head. Like, no
And
one.
if you can turn to that page, if you don't mind,
I'm there.
on the left-hand side, the first full paragraph. And it reads, in United States versus Young, which is Y-O-U-N-G, the Fourth Circuit did not explain its decision, but held only that the district court did not abuse its discretion. The holding in United States versus Young may be explained by the fact that the Fourth
Sure,
Circuit
y'all watch
was
Brian
applying
and Adrian.
the previous version of Rule 16, which used the term evidence in chief. Unlike Judge Friedman in United States versus, and I'm just going to spell it if you don't mind, HSIA, the Fourth Circuit did not define evidence in chief as case in chief. And then it goes through defining case in chief. The advisory note, I skipped 3 lines, Your Honor. The advisory committee notes to the 2002 amendments state that the change from evidence in chief to case in chief may be substantive in nature. The term evidence in chief may have, as the Fourth Circuit held, encompass both the parties' case in chief as well as a party's non-impeachment cross-examinations. Even if the term evidence in chief encompassed all non-impeachment evidence, including cross-examination, this broad term does not mean that the term case in chief does as well. The Fourth Circuit in United States versus Young indicated that a party's case in chief encompasses the time in which a party calls its first witness until it rests by repeatedly using the term case in chief in that manner. So I tell you this because the Waddell case goes back to the Young case. The Young case is a federal analysis of a rule that we don't have in Georgia. In addition to that, there have been 0 circuits following United States versus Young. Georgia has never cited Waddell or Young, but Georgia speaks directly on what our law is. And there's 2 different cases, Your Honor, with the same name of Green, Green. And if you can take a look at the most recent Green case, which you should have in your package.
Yes.
And for the Honorable Court Reporter, this is going to be Green, no E at the end, and it's 368 Georgia Appeal 74. 889 Southeast 2D 190 2023. And what the Honorable Judge Pipkin, which is P-I-K.
I wish Brian would
P-I-K-K-I-N,
get to it, y'all. Y'all
and
gotta
Your Honor,
watch
you could
this,
look at
but it's
if you don't
important
mind.
because at least Brian states case law, and that's what
At
an
this
argument
case
is
of
about.
page
It's
3 of
about
5,
stating
a copy of
relevant
the
case
parties
law
and this Honorable
and
Court.
tying it into the facts.
Footnote 3 is at the bottom left, and it reads, We also agree with appellant. This case was reversed. So let me just take a step back, if I may. What happens is the state did exactly in the Green case what Ms. Love's asked you to do here. They said that the lawyer for Mr. Green had evidence for a while, didn't turn it over until the day of trial. The judge excluded it because the quote, and this is a quote, sat on it too long. Therefore, the state was prejudiced and excluded the evidence. And the Court of Appeals said, you know, there was no evidence of bad faith or prejudice analysis, so we're reversing. But they dropped this footnote.
Mhm.
And the footnote they wrote, and I'm quoting, we also agree with the appellant that it is not at all clear that the defense failure to timely disclose, and I'll just tally them, but TALON note was in fact a discovery violation, given that talent was a state's witness, COCGA section 17-16-7, requiring the production of statements concerning the testimony of witness. That, and it's in italicized, so it's stressed, the party in possession, custody, or control of the statement, and then in italics, intends to call as a witness at trial. I didn't call these witnesses. I don't intend to call these witnesses. The next line goes further, and I'll explain it.
I'm gonna stop right here just to explain to you. So Adrian pretty much has argued 3 times. All 3 times, even Judge Glanville, who's no longer on the case and who a lot of people didn't agree with his rulings, ruled that she was wrong on this. She has argued that there are these interviews that took place that Attorney Steele had and some jail calls that took place. And she's arguing that they need to turn this evidence over. And the interview is with Bean. Y'all, Bean has testified on direct and cross and is sat down. And she's still arguing about an interview that's not been used, that wasn't used. There's no intention on being used. He wasn't the defense's witness. He was the state's witness. And she's arguing that that is an example of things that have not been turned over. But when you continue to watch, you'll see even Judge Whitaker is confused as to why she believes that should have been turned over. Ms. Jefferson,
That's a cover up. Y'all know what she wants. She wants that audio. She wants that audio that he said Hilton was trying to find on the internet. They think it's some kind of incriminating something up there that says somebody else unalived nut. And she thinks that Steele has it. So she's trying to use this little situation with Bean and the other situation. Who else already testified? D'Angelo White, trying to say that she
Murphy, right?
Yeah, she keeps saying all these little tapes, but they've already testified and already sat down. So what do you need it for? She's trying to get her on her side so she can say, hey, I think he got this audio about nut and I want it. That's all she's trying to do. She's going to try to put other stuff in there, using some stuff from 78.
The case is from 1978.
If you don't mind, it's very easy to explain.
Yeah.
However, we assume, I'm just reading the footnote, for purposes of this opinion, that the note was subject to discovery, and we need not resolve the question or address any possible tension between, and then it gives the 2 code sections that we're dealing with, OCGA 17-16-4, little b as in Barry 1, and OCGA section 17-16-7. So if we look now, and I should have given this honorable court and the parties a copy of both code sections, OCGA section 17-16-4. If you look at that first, assuming everyone has it, and it starts for the criminally accused obligations under the Discovery Act, and Mr. Williams did, in fact, opt into discovery. And if you look at the copy I've given this honorable court and the parties, it starts on the very bottom of page 2, but it just says B as in Barry, but it really goes over, Your Honor, to page 3. And that's where the one is in 1716-4 in the copy I've given. And it says that the defendant, within 10 days of timely compliance by the prosecuting attorney, but no later than 5 days prior to trial, or otherwise ordered by the court, shall permit the prosecuting attorney at a time agreed to by the parties, or as ordered by the court, to inspect and copy books, papers, documents, photographs, tangible objects, audio and video tapes, films and recordings, or copies or portions thereof, and to inspect and photograph buildings or places which are within the possession, control, custody, or control of the defendant. And this is what I stress, Your Honor, it's stressed in the footnote, and which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at trial. Your Honor, under OCGA section 17-16-7, if you look at that, and I've given a copy of that to Ysl Court and the parties. And that has, give me 1 second. That has no later than 10 days prior to trial, or at such time as the court permits, or at the time of any post-indictment pretrial evidentiary hearing, other than a bond hearing, the prosecution or the defendant shall produce for the opposing party any statement of any witness that is in possession, custody, or control of the state or prosecution, or in possession, custody, or control of the defendant or defendant's counsel that relates to the subject matter concerning the testimony of the witness, that the party in possession, custody, or control of that statement, and this is what I stress, intends to call at the trial or such post-indictment pretrial evidentiary hearing. I didn't call these witnesses. So the reason that it is so important is we're just dealing with whose case in chief. Georgia doesn't have the pre-2002 Rule 16 analysis that was done in United States versus Young. This is not even close. Page 5 of 7, and Your Honor, I am now in the other green. So it is GREEN versus state, but it's 307 Georgia 171, 835 Southeast 2D 238. It's a 2019 case. No relation that I know of. It's in Division 4. It's on page 507, like I said. Left-hand side, the last line before the footnotes, 2 lines up, actually. It says, however, that is not what Georgia law requires. As provided by the plain language in 1716-4B2, the statute does not require a report to be prepared and made available or served unless the defendant intends to introduce in evidence the defense, I apologize, in the defense case in chief or
Judge Whitaker she spent a time on this talking about case in chief. She spent a lot of time talking about this, and it's because the point of it, and the reason why I think this part is important, I know it's long and it's not the most exciting part, but what's important about it is the fact that Adrian cannot accept no. There is such a delay in this trial because she cannot accept no. We have all of these witnesses, all of this extra stuff going on. For what reason? So once again, you get up there and you argue about a witness that has gone up and down, and a witness who Brian says he's not going to call, evidence he says he's not going to use. And even if he was going to use it for impeachment, the witness is done. So why are we talking about this evidence?
rebuttal the results of the scientific test or experiment. If you go to the next case, which should be, or another case, I don't know if they're in order, but it's Carmichael, Your Honor, which is CARMICHAEL versus state. 353 Georgia Appeal 64. That's 836 Southeast 2D 184, 2019 case. And Your Honor, if you can turn to, from the copy of given Ysl Court and the parties, page 7. of 8. And Your Honor, this is on the left-hand side, the first full paragraph, but counting from the bottom. 9 lines up on the right. I'm quoting from our court, and this is just one case. There's so many. Just before the state rested its case in chief, the trial court instructed the jury that when a stipulation is entered into the facts, as to facts of other parties, you can accept those facts as being true without further proof. My point is, their case in chief is, it's a term of art.
It has a distinct meaning.
Yes, and if you go back to the Harry case, it's actually a fascinating case to read. It's an enjoyable case to read. They go through case in chief versus evidence in chief, and they talk about specifically all the U.S. Supreme Court cases. It's on page 8 of 17 of the United States versus Harry, Your Honor. It's a well-written, it's really a good job. On the left-hand side, the first full paragraph on page 8 of 17. And the district court in New Mexico wrote, courts have repeatedly used the term case in chief to refer to the part of the trial between the time that a party calls its first witness and when it rests. And then they go through all these United States Supreme Court cases that talk about that. I mean, it's not even an issue. So I, for the 4th time in doing this, the state then has, or the court said that wants to know about Waddle. Waddle is different. Waddle specifically, and I assume that you have the case because I heard you refer to it. If not, I can get it.
I do.
So in United States versus Waddle, which is WADDELL, and it is 2016 U.S. District, which is DIC period, Lexus, LEXIS 68748. It was decided and filed on May 25, 2016 by the district court in Southern District of Georgia in the Savannah Division. Your Honor, if you go, and I'm not saying we have the same copy, so this is on I have page
Maybe what page of the slip opinion?
I'm trying, I think it's page 11 is what I'm looking at. It starts out with one
Right.
final point.
Mhm.
Okay. So the Waddell case, the judge said, no, you don't have to give it over. But if you're lying, that's, I think, I'm not saying that's
Right. Now I read it. Yep.
Then you're going to be in a lot of trouble or something
Right.
to that effect. But what happened in the issue in Waddell was they were talking about a statement given to the accused before the indictment. So it wasn't done under the auspices of work product, where the lawyer goes out and interviews witnesses. What Ms. Love tries to do is, I would have a chilling effect. I interviewed every witness that would talk to me. I interviewed everybody. And what Ms. Love is saying is, give me your work product. If I'm not going to use it the way I understand the law, unless you tell me differently, I'm not giving it to the state. So
That's my understanding as well.
So when she says, Mr. White, and I heard what you said, they didn't use it, why would you ever get it? That's exactly right. I hardly cross-examined Mr. White. But the state is telling me to give it. They went so far as Ms. Love called our investigator and tried to get involved and break the attorney camp. She told our investigator, she can call me, give me any recordings that you have of Mr. Bean, the investigator's skill. So he must have said, I wasn't on the phone. But Ms. Love then reported it to Judge Glanville, who said that was appropriate. He shouldn't have given me anything. Said, Mr. Steele's investigator's obstructing us. This is so wrong of the prosecution. 4 times I've given the same case. 4 times I gave that Green case. 3 times Judge Glanville ruled. In addition to that, there's factual, not only, am I rejecting, I am never taking Ms. Love's proffer. Okay, so she says that I said, I don't talk with Ms. Love, by the way, if you didn't know that. So I never said anything to her. But that I
Is there
said,
somebody on the state's case that you are able to talk to?
yeah, Ms.
Okay.
Willis.
All right. Well, okay.
On
Go ahead.
the second page, and I'm just looking at the amendment to supplement on page 2, in the center of the page.
Right.
And I should start above, but I'll get to that if you don't mind. For another example, defendant Williams, it's me that she's talking about, has asserted verbally that he has a video recorded statement of Kenneth Copeland in which Copeland reportedly asserts we killed Nutt, referring to Donovan Thomas. Well, let me tell you how that happened. I never said that. Ms. Hilton sends an email and says, upon interviewing Kenneth Copeland, we found out that he put out a social media recording that he killed Nutt, or we killed Nutt. It's in writing.
Is this what you talking about, Miss Jefferson?
Yes, he's getting ready. That man, she's getting ready to be gathered. I was so, but I know for a fact when he said he told 3 times, I think this is also the one that he was talking about where she lied about the evidence while Bean was on the stand. She was like, I have evidence right now on my table that shows, and what, nothing on the table. That's how she got Glanville to argue it the second time, because she misrepresented what it was going to say.
Can you please give it to us? We can't find it. The most I may have said, which I don't have a memory of saying anything, is I'm not giving you anything. If I use something, I'll use it in court. That sounds like something I would say to these prosecutors. To other people, I would say, you're going to have to, I don't have to give that to you, and I'm not going to be able to talk about that. I never said, I verbally asserted that I have anything. But if I do, I'm going to say the same thing that I'd always say. I'm not giving it to them. If you tell me to do it, I'll do whatever. But I'm not going to give them anything because I don't have to. That would be impeachment. Mr. Copeland, before the 12th day of June of 2024, specifically was asked by Ms. Hilton, did you kill Nutt? And he said no. That would be impeachment. The next one that I did not give over Mr. Copeland's jail calls until recently. Let me tell you the truth. October 2023, I gave jail calls of Mr. Copeland to the state. October 2023. The state doesn't raise this until more recently when Mr. Copeland is a witness. They want me to tell them which jail calls am I going to use to impeach the man. I said, I'm not going to do it. Judge Glanville said, you don't have to do it. I'm not going to do it unless you tell me to, but I don't understand how I'm doing this. And then to stand here and say, I just gave it to him is preposterous. In addition to that, then we go to the first one, Mr. Bean. Mr. Bean testified for days. This case, Your Honor, has taken so long. I don't know how long he was on the witness stand. It would not shock me if he was there for 3-4 days. All he said was, I don't recall. That's what he said. I don't recall. Did you say this? I don't recall. I don't recall. So the state got in his prior statements to Detective Quinn. Well, I impeached him. He gave me a statement on recording. The state then doesn't ask Mr. Bean in front of the jury, doesn't ask him in front when he's here to be cross-examined. They come up with the Judge Glanville ex parte, give him some sort of document that supposedly shows Mr. Bean is scared, which I doubt. This is just me, doubt out of no evidence. And then in the middle of that document says that Brian Steele and his investigators, I'm not quoting, were in a car with Mr. Bean and his son. And Brian Steele was telling Mr. Bean what to say. And his son has that on recording. That never happened. That never happened. But what Ms. Love was allowed to say in front of the jury, believe it or not, did Mr. Steele stop and start that recording? Mr. Bean said what he always says, I don't recall. I objected outrageous. Outrageous. It just flows right through. The same way Ms. Love stands here today and says it's hard to hear, or whatever her words are, hard to decipher on an Apple iPhone.
Wait, did y'all see the eye roll?
She don't want to know whether she mad. Oh, she's so mad that old case law ain't working.
Did y'all see the
she's
eye
so
roll?
mad.
Oh my God.
Ooh, that's okay, love. Your time is coming. Few
That
seconds.
did not happen. It is offensive. The legal analysis is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong. And this lawyer knows it because she sat here in court and I did the same thing without being tempered.
All right.
That's 4 times.
Thank you for clarifying that.
Your Honor, may I briefly respond?
Yeah, when Mr. Steele clears the area. Yeah, go ahead, Ms. Love.
Thank you, Judge.
Do you have it?
Okay, so y'all saw that he better not touch me, right?
And
But
I'm so glad she had to sit there. She said, yeah, when he clears the area. Because she's been doing that the whole trial, jumping up, walking over, scooting, bumping people out the way, taking over at the, like, yeah. That's
well,
okay.
and then when she gets up right now, it's even this, I think, is this the part where she embarrasses herself the most?
Yep, she's about to get laid because she's about to lay into her.
Okay, here we go, guys. Let's watch.
Any Georgia law that represents what
Not
you
you
have
got any
asserted
Georgia
in
law.
your motion and amended motion?
Your Honor,
Specifically.
that's just it. I have been clear in my amended motion.
Yes or no?
And
Which
to the
I
extent that it
just got
wasn't.
a copy of.
Yes.
Okay.
And also, I just want to say that.
No Georgia law.
Right. Georgia law does not define, it does not define case in chief. It does not break it
We all
down.
know what a case in chief is. Don't we? I think we all know what a case in chief is. Is there any support for your assertion that reciprocal discovery is required based on the concept of substantive evidence?
Your Honor, what I have said and what I maintain is that, one, there is an absence, and I'll point the court to 3 different cases, Harris versus the state 314, Georgia 238 as one. And these are just instances.
238? What did you say?
Yes.
Okay. What are the other 2 and what are they going to represent?
307 Georgia 171, which is the 2019 Green case that Mr. Steele cited for the court, and 146 Georgia App 423, which is Phillips versus the state. And
when is that from?
I'm sorry.
What year?
Just 1 second, Your Honor. That's a 78 case.
Okay, so that one's not relevant at all.
Old case.
Because we have a new evidence code since 78.
Wait a minute. Did she say, okay, so that is not relevant at all?
She said, okay, so that's not relevant. And then she keeps going like, did we not have a law after that? Did we not have a rule now?
She said, okay, so that's not relevant at all.
78. You got all the way up there and skipped the year.
Okay, let's keep going.
So, okay.
And Your Honor, even with respect to the older case, the only thing that I was citing Phillips for was the proposition that in the absence of specific legislative or decisional case law on the particular issue that is at hand in Phillips, we commend the Federal Rules of Criminal Procedure, Rule 16, for guidance.
Well, we've got a specific rule here now, don't we?
Well, when you say we have a specific rule, is the court speaking of the discovery statute that says?
That's what we're talking about in this motion, right?
Right, yes, Your Honor. We are talking about that, and the state's position, the state maintained, first of all, let me be real clear, we didn't file a brief. This is the first brief that we have filed where we've asserted these things. We have asked that the court require Mr. Steele to turn this stuff over, but we've never argued it out. Mr. Steele has stood up and said he's not required to, and he has pointed to the discovery statute. The court has said, okay, yeah, he doesn't. And we put that in our motion to the court, that the court has previously made a ruling that we thought deserved a second look at. Defendant Williams has adopted as his witnesses all the state's witnesses in the witness list that he filed. And so, Your Honor, when we assert based on Waddell, and Waddell also speaks about work product, and it makes this distinction between factual history and work product and what the state or is and is not entitled. The state stands on its assertion regarding what the requirements are because of the fact that I understand the court's position that there is no misunderstanding about what case in chief means in Georgia. But as there was,
does anybody know what she's talking about right now?
Expounding on its meaning
Her assertion in
Waddell, I think it's important to recognize that there's not been a similar sort of expounding in Georgia, and we can all presume or take for granted that it just means when the defendant is putting up his particular case. Right.
Okay, so do you have any case law
in Georgia
that supports the position you took in your motion that reciprocal discovery requirements are triggered based on whether you're presenting something as substantive evidence? That's my question to you.
Your Honor, the only what we have in support of the motion is cited in the amendment and in the motion itself. We have not ever presented or represented to the court that there was a Georgia case that addressed this issue, and the conclusion that is asserted in the state's filings are the result of the fact that, one, from our position, it's not addressed directly, that, what case in chief specifically.
So you are telling me that when our discovery statute.
Pause, because it's the chuckle for me.
She had to laugh. She had
It's
to laugh
the
at that
chuckle
point.
for me.
Because, girl, no. The answer is no. You don't.
I'm going to rewind it just a little bit because I got to hear that again.
To the court that there was a Georgia case that addressed this issue, and the
to the judge.
Conclusion that is asserted in the state's filings are the result of the fact that, one, from our position, it's not addressed directly, that, what case in chief specifically.
So you are telling me that when our discovery statute says that the defendant is to produce or permit inspection and copying of whatever it is that they're in possession or control of, which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at the trial, you think that there's some kind of lack of clarity about what that means? Is that what you're representing to the court?
Your Honor, I'm representing that was the position that was taken. That was what was analyzed in the cases that we have cited in our amended amendment and supplement to our motion to compel. That is, in our position, a reasonable interpretation. And as we've said in our filing, Your Honor, there was the requirement in Waddell that anything that was within the defendant's possession, custody, or control, where the defendant intended to use the item in the defendant's case in chief, that be turned over. The Waddell Court, Your Honor, in analyzing the meaning and understanding of case in chief, as the court correctly pointed out earlier, said that if it is going to be used as both impeachment and substantive evidence, that constitutes case in chief. From there, we made the assertion, the state's position, that if the defense intends, because there's nothing in Georgia law that analyzes it at this level, if the defense intends to introduce evidence as both impeachment and substantive evidence, then they have a duty to disclose it. And that is the origin of the state. That is the basis for our position. If you're
And have you heard Mr. Steele argue 2 or 3 times before that that's not at all what Georgia law means?
We've not made this argument before. So
I don't mean in writing. Y'all have not had any discussion whatsoever in front of Judge Glanville about.
As I have said in my motion, Your Honor, what we have argued, the state has said, Your Honor, they have a duty to disclose this. This is stuff that we are entitled. And Mr. Steele has said no, in citing the Georgia statute. He said we do not. I have never asserted, I've never made this distinction. I've never said that case in chief means if it's being presented as impeachment as substantive evidence. I've never made that. I've never made that argument in a written or oral filing.
Okay. All right. Well, I would like for you to take.
I have to pause right here because listen to what Judge Whitaker now says. We would have never got this from Glanville. I'm sorry to say it. I don't normally take sides, but listen to this, guys.
Your duty of candor to the court with a little bit more.
If the defense intends, because there's nothing in Georgia law that analyzes it at this level, if the defense intends to introduce evidence as both impeachment and substantive evidence, then they have a duty to disclose it. And that is the origin of the state. That is the basis for our position. If you're
And have you heard Mr. Steele argue 2 or 3 times before that that's not at all what Georgia law means?
We've not made this argument before. So
I don't mean in writing. Y'all have not had any discussion whatsoever in front of Judge Glanville about.
As I have said in my motion, Your Honor, what we have argued, the state has said, Your Honor, they have a duty to disclose this. This is stuff that we are entitled. And Mr. Steele has said no, in citing the Georgia statute. He said we do not. I have never asserted, I've never made this distinction. I've never said that case in chief means if it's being presented as impeachment as substantive evidence. I've never made that argument in a written or oral filing.
Okay. All right. Well, I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms. Leff.
Respectfully, I take it very seriously.
Okay, so anyway, we'll be abiding by the discovery requirements set forth in our.
Oh, she say anyway.
Anyway, she said, "Stop playing with me. Stop."
She didn't even address it.
She didn't know she was lying. That just means this is the 4th time you shopped something different to try to figure out how to get this argument to work, and it didn't.
And even from the beginning, I think that she states that she doesn't agree with the representations made in the motion. She says, oh, I got to go back to it because she says, who wrote this motion? Because whoever wrote this motion, at the beginning, she says, who wrote this motion? I'm going to go to that. I'm going to let y'all hear this part. Because even though I'm going backwards, it's like, I don't even believe she wrote it. I think that was a lie. Because I'm not going to say I think that was a lie, but she wasn't really saying, oh, I wrote it. Let me go to that part.
Well, I was hoping they said something about that motion anyway, because that motion went in Friday night after 11 p.m. Like, ma'am, new motions were due on the 23rd. I was wondering if she was going to say something about her turning that in, because I know you didn't think that just because you were the state that you had till Friday and nobody would get a chance to respond to it. But when she asked who authored that,
and then she says about the amended part, and she says, oh, I just submitted that yesterday.
She turned that mess in Friday night. I think we caught it at like 11 something at night. I think when she emailed and said, who authored this? They need to be in the courtroom on Tuesday. She hurried up and changed it because she was like, show me where it says this case law. Because I don't know nothing about this. Show me right now. Like, woo, she was tapping that today.
But that was this motion, right? I'm at the right place, right?
This was the motion to compel. Yeah, the motion to compel.
Okay, let's see.
Who wrote it?
Specifically as to the authorship.
GA 884. I used in Ward, it's dealing with kind of the outer limits when someone's claiming self-defense.
All right, the state has a motion to compel defendants' compliance with the reciprocal discovery obligations and to exclude evidence intentionally withheld and not timely disclosed. And I had via email asked specifically as to the authorship of this particular motion and to have whomever authored this motion be present in court. The response I got back was Ms. Love saying, I will be present. Does that mean, Ms. Love, that you are the author of this motion?
Yes, Judge.
Okay. So I have some problems with some of the representations made in this motion.
Lies.
I love the fact that, okay, if you're going to claim this baby, let's get into it. And that's what she did. She made her claim. So whether who wrote it, you're taking ownership. So I guess that's you that's about to get embarrassed. Here we go.
Specifically on page 3, the citation to U.S. versus Young, and then to U.S. versus Waddell, and then the statement, quote, a defendant has a duty, underlined, to disclose prior to trial and an ongoing duty to timely disclose, in bold, any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence. See id, meaning see the above two cases, Waddell and Young. I've read both of those cases. Show me in either of those cases where there is a proposition that discovery and reciprocal discovery obligations of the defense applies to evidence that's going to be used solely as impeachment.
I didn't say solely as impeachment. I said as both impeachment and as substantive evidence.
Which implies that the use of it as impeachment evidence triggers the reciprocal discovery obligation.
No, unless I wrote it inartfully. What I was saying.
Well, you wrote it inartfully.
I did then, because what I was saying was that it has to be both. That is the representation that
all right.
I made. And then when I amended it.
I didn't see an amendment.
I have a copy for the court.
Did you fix that?
What I did was.
Thank you.
Sort of.
Did you fix it?
Yes, I guess you could say it was fixed.
Not until you got caught.
So you concede then that if evidence is going to be used solely as impeachment evidence, that there's no triggering of a reciprocal discovery obligation?
Yes, that's
okay.
Yes, I was not saying that. I was saying.
Good to know.
My apologies to the court for that inartful wording.
Okay.
And what I said in the amendment, Your Honor, was.
Did you email the amendment to my chambers?
I did.
Okay.
Yesterday.
Yesterday. Okay.
Yes,
well, that may be why I hadn't seen it, although I've been looking at y'all's stuff nonstop.
Yes.
Okay. It's in front of me now. So.
So what our position is, Your Honor, as I state on page 3 of the amendment, is outlining what Georgia's statutory requirements are. Of course, the court is aware of what OCGA 1716 4C1 requires. And then I go down to subsection C on that same page where I cite Aggie versus the state 311 Georgia 340 at 343 and go on to say Georgia's discovery law does not explicitly apply 1716 4C to evidence used simply for the purpose of impeachment.
Okay.
And then I say it unquestionably applies to that second intended purpose, use as substantive evidence. And then in section D, Your Honor, I cite to relevant similar federal laws, pointing out that federal law requires the defense to provide the government with materials that are within the defendant's possession, custody, or control. Possession, custody, or control, my apologies. Where the defendant intends to use the item in the defendant's case in chief at trial. And that's Federal Rules of Criminal Procedure 16B1 alpha.
Okay, we already went through this, but I mean, okay, what you think, Miss Jefferson?
She got caught lying. She turned it in. She got an email that said, "Who wrote this?" And she said, "Let me go back and fix that." That just made me scared, to be honest. The same way I was talking about, you know, we don't know what's happening behind closed doors with normal people, with these deputies and stuff like that. Like, how many times have you prepared a motion where you cited real case law, but made it say what you wanted it to say, and somebody didn't look into it or somebody didn't catch it on a regular person where nobody's paying attention? Like, that's scary.
I mean, just to watch, it's hard to watch. I'm not gonna lie to you, it's hard to watch. I mean, even with, it seems that she was goaded. That's the word of the day, into even admitting she was the author.
And wouldn't have. And my thing was like, you put your name on everything else. Why didn't you put your name on that one? Everything else said who wrote it. Like, why didn't you put your name on that one? Like, you knew it. Y'all was just trying to see if it was going to fly. And then you know good and well that yesterday, like, that doesn't give anybody time enough to get through it, get to it, and all the other stuff that she had to get through. Like, yeah, I just feel like she got caught.
Okay, and so, I mean, my whole thing is, another thing that has bothered me, that bothered me today, is that I'm gonna talk about this, and then I want to listen to some of the bond motions, and then I'm gonna get off. But how come everybody is saying that Judge Glanville was recused, but he didn't do anything wrong? Like, I don't understand how they continue to say. Go ahead, Ms. Jefferson.
Oh no, you got it. I'm just over here running my mouth. I said to save face. It's all for the look of things. It was in my personal little 13th juror opinion, to save face, not to let anyone see the chief judge fall, not to keep his pension, his legacy, and his career intact. So they knew he needed to be recused, but they just wrote it in a way where this ex parte was not wrong. Their actions were not wrong. There was no misconduct, but we'll remove him for the look of things because it just doesn't look good. It was to save face. I think you're still muted.
Okay, yeah. So I was just saying, I just think it's also interesting that she brought up multiple times that he is a former prosecutor. I mean, she's a former prosecutor too. I think that Judge Whitaker did a great job today. So I am not taking away from that. I think that we should definitely give her grace. I think she was fair, and that's not what I'm saying. But the main thing that bothered me today is that I think when she woke up this morning, and I say this all the time, I have judges tell me all the time, when I woke up this morning, I knew what I was going to do. And I think when she woke up this morning, she had never intended to hear those bond motions. And that's the only issue I have. Everything else I think was great.
I just feel like she had, just like you're saying, yeah, she woke up this morning, knew what she was going to do. I just feel like at this point, she's determined to bring this full circle still for the look of things to save face. I think they're just looking for it to not be Fulton County's fault. I think they're just waiting for us to, if we can at least get this to a verdict, no matter what that verdict is, wasn't our fault. That's the jurors. We have to respect it. I think they're just not don't want to let it fall on their hands. But at this point, like, what is it like? If y'all think that recusing him and saying that that meeting was wrong, it was an issue of the way it looked, like, what do you think this looks like?
I'm gonna play some of Carrington Matthews' bond motion, because we never get to hear Carrington. We always hear Steele and Shard and Weinstein, but I think that Matthews did a great job.
Mr. Huey has a motion for reconsideration of bond with asserted change circumstances of the ex parte being a critical part of the trial that he was excluded from, and having been held longer than he otherwise would have because of the delay resulting from that. Do you have anything to add to that, Mr. Matthews?
Yes, Your Honor. Good day to this honorable court. Carrington Matthews for Mr. Marquavius Huey. I cite for the court Wimbush versus the state, 345 Georgia App 54, which is cited in my motion. When a court has previously heard a motion for a bond, its ruling is not subject to change unless the court finds that the movement has presented new information, testimony, or evidence that indicates a change in circumstances. Wimbush, when it talks about new information, new testimony, or evidence that indicates a change in circumstances, I would like for the court to consider that the change in circumstances as it relates to this particular proceeding is that when the court denied the bond to Mr. Huey back in 2022, it determined that he did not meet the Ayala factors. This same court, in making that determination in 2022, the change in circumstances, the new information, the new evidence is that that same court that denied the bond in 22, that court indicated in or on June 10th, it had a meeting that this court has heard over and over again now with the state, right? With a sworn witness, right? And in the transcript, Your Honor, the court that denied the bond to Mr. Huey then, that court engaged in conduct which I believe influenced the witness, caused that witness to reconsider his position that he was not going to testify, talking about Copeland, caused that witness to, rather than say, I'll sit in jail, co-signed on the state of Georgia's recitation that, no, Mr. Copeland, you will sit in jail until every single defendant on this indictment is tried. So what I'm asking the court to do is look at what is the change in circumstance here. The change in circumstances, we want Mr. Huey. He wants an unbiased, a neutral referee to decide whether or not he is a good candidate for bond. I would assert to this court that that has been clouded because a neutral judge, a neutral referee would not have engaged in the conduct on June 10th, which essentially is why he has been recused. So I'm asking the court to say, hey, look, there has been new information, because that was not information that existed when the court decided that Mr. Huey was not a good bond candidate. That was not evidence when the court decided that he was not a good candidate. And we're looking at a judgment call here. The court has to be comfortable. The court has to be confident that when a request for a bond is made, that the candidate, based upon the change in circumstances, would be a good candidate for a bond. Now, Mr. Huey has been in custody since December 14th, 2021. It's a long time. Now, Judge, we have been out of court, out of session for over a month and some change and still counting. That delay, Your Honor, is a change in circumstance for Mr. Huey. He is on 23-1 at the Fulton County Jail. He's on lockup for 23 hours out of the day. 1 hour out. We don't have to go over and over what the conditions are at the Fulton County Jail. We know what they are. The news media shows us what they are. He tells me what they are. When I go visit him, I see what they are. So what I'm asking the court to do here is look at those change in circumstances. Now, here's another factor. How much, Your Honor, does it cost the taxpayers of Fulton County, Georgia, and the state of
Mr.
Georgia?
Matthews, that is not an appropriate consideration for bond.
I would ask.
Period.
Understood, Your Honor. I'm asking the court to look at the resources that are required to have Mr. Huey here every day. That's all I'm asking the court to look at.
Consideration for bond. All right.
So essentially, Your Honor, I'm asking the court to look at the change in circumstances that I have cited in my bond motion. I'm asking the court to take that into consideration, that the decision to deny the bond for Mr. Huey in 22 was made by the recused court. And the change in circumstances that I am alleging were done by the recused court.
All right.
Based on judgment calls.
Okay.
So, Judge, I'm asking the court to set a reasonable bond with conditions. Here's what I'm asking the court to do. Put a number on the bond. I'm asking the court for a $50,000 bond. I'm asking the court that Mr. Huey be required to live at a certain residence here in Fulton County, that he be required to have 24-hour house arrest on a monitor, right? He be required to only come to court and only meet with his attorney for the duration or the rest of the proceedings of this trial, if it gets that far. Obviously, to have no contact with any other co-defendants in the case, and for any other reasonable conditions that this court believe would be meet and proper based upon our request. We believe in 2022 that the Ayala factors were met. The court has indicated, obviously, that the other court made that decision, and then this court wants to hear about the change in circumstances. I think I've efficiently been able to lay those out in our motion, support it with proper case law, and also I would, just for the record, I would address the case that I cited with respect to the ex parte meeting, and that's Scudder versus the state, 298 Georgia 438, a 2016 case.
What was that site? Is it in your motion?
It was in my motion, Your Honor.
Okay.
And the Scudder Court determined that a criminal defendant has the right to be present and to see and hear all critical parts of his trial.
Okay.
So forth and so on.
That's with regard to that substantive issue.
Yes, Your Honor,
Okay.
which we are alleging is a change
Okay.
in circumstances.
I'll just stop it there. I mean, I think he has some really great points. And the reason why I care about his bond is because we heard Steele's motion. We went over that last night. That has pretty much been the same the whole time, with the thug willing to get the off-duty officers, willing to submit his phones, willing to do this. And what is the change in circumstance here? I think your judge being recused on an 18-month-long case is definitely a change in circumstance. But I also believe that Judge Whitaker, some judges just have their things. And I think that once bond is set by whatever judge bond is set by, she sticks to that.
That seems to be how she felt about what she said about Krause too. She said that she agreed not only with Steele, she agreed with Sharp that Sharp said, Steele said we want to question the factual findings, or basically how she got to the recusal. Sharp said, I agree with we need to revisit it. Mommy. Yes, baby. What? Okay, thank you. But he said we need to look at the factual findings. And Sharp said there were no facts. But Sharp said there were no facts in there. And she agreed with Sharp, but she still said she wasn't going to re-review anything that Glanville did. She just looks like she just will not go step on the toes of another judge.
And I've had a case before her. I've only been before her 2 times. And now, it was brought back to my remembrance that is how she handled me. It wasn't that she denied my bond motion. It's simply that she would not even reconsider it because another judge, a first appearance judge, had already heard it. And, I guess that's just what she does. But other than that, I think she did a great job today. I think she was fair. I think she ran her courtroom very well. It was not my phone that rang. And I was outside arguing about, can I bring my phone in? And also, this is the last thing I want to talk about before we get off. I want to know what they are talking about, some ex parte meeting that happened on Friday that included me, because I was in Houston on Friday. And they keep saying something about something that happened on 10/7. I don't know what they're talking about, guys. Did you hear that, Ms. Jefferson?
I heard it, but I was trying to figure out what it was. I know they requested, because I was watching today, I know they requested to know how the June 10th one was requested. But then when they said your name, I'm like, but Melnick,
I was sitting in the courtroom like, can I come up? Can I come up? Because I want to see it too, because what's going on?
That's why I can't be in that courtroom, because I'm be objecting from the They'll have a law degree to first and be, hey, hold on, wait a minute. Because I'm like, wait a minute, Melnick was there on Friday. That's when all the mess took place. That's when he said the answer 2 questions and said, I plead the 5th. He didn't come back till Monday. So I was like, what? Maybe somebody was mixing it up. I don't know. I thought that's what she handed out at the end was those, I guess a rough draft of the Miss Weaver, the old court reporter's, I guess, recollection of what happened or what would be the transcript of that. But I was like, when I thought I heard him say your name, and I'm like, that can't be.
No, I was sitting in there, Miss Jefferson, like 6-7. I wasn't even involved in this on 6-7. I'm like, everybody's walking up. I'm like, can I get up and walk up too? What's going on? Because what's going on? And not to say anything about Judge Whitaker, I honestly think it was just a overwhelming amount of information, and she just kind of mixed me up and forgot that Melnick was there on 6-7. But I want to know who was present when this meeting was requested, because I don't even think he was there. Because when I talked to Melnick, he had no idea of a ex parte meeting.
And the other thing was, I was like, who can get their hands on that transcript? I want to see it, because the whole case law that Glanville cited about why he had that ex parte and didn't tell anybody was for safety and security. She said because of Melnick's email, it was about safety and security. She stood her old tennis ball head up earlier and said that she requested it because of Melnick, because of his representation. Like, if you requested it on Friday because of his representation, then that's one thing, but that's not what you said. And that's not what Glanville even cited as his case law as to why it was okay. So now that you're standing up in court saying, hey, we did it for this reason, and it's not the same as the first one, like, and we still got Krause saying there was nothing wrong with it.
We still got Krause saying nothing is wrong with it. We got Whitaker saying nothing is wrong with it. I'm just confused. If nothing was wrong with whatever happened, why did we get the recusal?
How can you say, even if you don't want to step on anybody's toes, she can say nothing was wrong with it all she wants, but she did agree today that Glanville lied to Woody. She agreed that Glanville lied to Woody when he said, you're going to have to sit here until we finish with everybody that has something to do with this case. So if you knew that he lied, that lie, we all knew by that time that one thing that man did not want to do was go to jail. So, you know, if you say something like that to someone who definitely did not want to go to jail, put out there that it was a child's birthday, put out there that give me a couple weeks, just don't do this on this weekend. Like, please don't do this now. And you knew that was the one thing he did not want to do was to go to jail. You knew he was going to do whatever he had to do to not go to jail if there was no timeline to it. And to find out that was all a lie, like.
And then another thing is about the timeline. You know, y'all know Simone is my girl. I don't care how y'all feel about that. I can't dispute that. But you know, today, like I said, I walked up, I say hi to Simone. I didn't say hi to Miss Love. I didn't have it in my heart to do it. And you know, but
I feel like Hilton got a soft spot with me and the rest of the family over on TikTok. I feel like she in a hard place. Like, she just stuck. I just be wanting to yell, run. I just feel like Love got that little, what was that, get out? Like, she just stirring that tea, like, run, girl, run.
But I say that to say, you know, when I was in that meeting and it's in the transcript, I say, if Melnick is going out of town just for a week, why can't we call Woody in a week? And I feel like that here, y'all have so much y'all could be doing in those 2 weeks. The jury is out the week of the 19th. You know, it already took 2 weeks for him previously to be the state's witness. We still have to have him as the defense's witness. We have multiple defense attorneys. Why do we not just take a break, get these motion and limines, get this evidence, get everything handled, and then bring Woody back? Or if not, why don't we just keep going? Because Melnick nor me got a pass. And I say in the transcript, why can't we just go to the next witness? And the state says we're not doing that. Now they want to go to the next witness.
They look so confused on that Friday. On that Friday, I believe it was Steele, he stood up and said, hey, every week on Friday, you tell us who to prepare for next week. So if this witness decides that he's not going to testify Monday morning, who do we need to be prepared for next? And they kept saying, oh, we'll have to let you know. We're not so sure yet. I knew some mess was getting ready to transpire. Then it's 2.5 hours late on Monday. I feel like they try to put all this on Woody's back. I don't feel like there's much, like 300 witnesses. Like, where is the case? Like, where's the eyewitness? Where's the, like, what do we have here? Like, and now, once she gets finished with this hearsay motion, like, how much of Woody's testimony is actually going to be left?
And then I'm not saying anything, like, I don't know anything as personal knowledge, but we have seen, because I've already been accused of violating attorney-client privilege. So this is not attorney-client privilege. It's just speculation. But what if he says in the transcript, I think it's page 23, but he says, I'm a liar. I have never told the truth a day in my life until just now. So what's going to happen when he come back and it's a completely different story? Then what happens?
Listen, I don't even think we're going to get this far. Because you know what? Everybody in that room going to be able to play pretend. Everybody can act like they didn't hear what happened with Woody. Y'all can take the notes of the jury and everything else you said you're going to do. Y'all going to put that man back on the stand and ask him the questions that he know he's already answered? This is not going to go the way y'all think.
Like, y'all going to put this particular individual on the stand, and he getting mad at you for asking him. This man pled the fifth on how old are you?
And I'm telling you, that man gonna look over at that jury. He gonna look out there and see still like, okay, I know I saw you. Like, you were here. Like, you only gonna play with him once. The second time, you gonna get what he give you. This is not gonna go the way they think. There's not gonna be another story.
But how do we explain it? I'm with Bruce on this YSL ponytail. How do we? I mean, how does this make sense to the jury?
It doesn't.
So they just won't come and listen to the same thing or something new or whatever he gives them, and I'm confused.
Even worse than that, like somebody like me, just a regular person sitting there, and you look at me and tell me to forget. First of all, you can pick a lot of people, and it's really not a lot, but one person nobody will ever forget is Woody. Nobody, whether you watch the trial or not, he's a meme, he's entertainment, he got one-liners. Like, everybody knows who this is. They've seen him. So nobody will ever forget it. But if I'm sitting up there and you say, forget everything he ever said, you don't know as a human what I've already committed to memory, what was funny, what stood out, what was something that made me either think whichever way I'm swaying. And then if she blocks out some of his testimony with the whole hearsay motion, then he gets up there, says stuff that's missing parts. My human brain may fill it in with something that I committed to memory, and then it's all mixed up with something that shouldn't even be. It's impossible. It's impossible. I don't know how they can do that.
And one thing I also thought was interesting, they want to know about all of this extra evidence that the defense has. The state wants to know about Turner. What about the other ex parte meetings y'all have had? What about the Brady evidence y'all haven't turned over? What about that? It's like they are completely ignoring the fact that we had two witnesses that didn't want to testify, gave them a weekend, same as Mr. Copeland, come back on Monday.
It just looks like a pattern. And unfortunately, at this point, they're getting to the point where people don't care what was done. People don't care that there's victims. People don't care. People see what's going on, and they're at this point, we're looking at Love as the Rico. They look like they're the bullies. They look like they're the ones forcing this. They're doing underhanded things. They're using crazy tactics. They're slipping in things. They're trying to get away. And so even if, and I can't even bring myself to say it, but even if she accidentally wrote something wrong at 11 o'clock at night and copied pastes from one place when she didn't mean to, which I don't believe, but even if it was an honest mistake, nobody will ever believe it because of all the things that have been done in the past with this case. Nobody would ever believe anything that she's doing. And unfortunately, she's a prosecutor. So she gonna prosecute. Nobody's gonna like it, but she's in a position where the way she's doing it, people are going to, the court of opinion is going to look at her like you're unfair. So they don't even care what has been done.
I mean, because this could definitely be a situation where there was a fair trial. You know, if we had everybody playing fair, straight down the middle, I think that public opinion would be a lot different. You know, still people will support who they want to support and, you know, be there for who they want to be there for. But at the same time, I think a lot of the hate and the anxiety and the animosity comes from rights being violated. And a fair trial, a speedy trial, you know, fair playing game for defendants not happening. And that is the problem here. And that's what I say all the time. For me as a defense attorney, and even knowing who I know or whatever, it's not about who's innocent, who's guilty. It's about everybody has rights. Everybody deserves a fair trial, and what's going on is clearly wrong. And that's my whole point in even saying what happened to me today, because I'm tired of it. Like how the whole world is walking around saying one thing about me, and that's how the internet works. People see these small clips, they see these small things, and they make these opinions, and you don't really know what the truth is. But I mean, she doesn't make it any better. She, makes these faces. It's completely like just sitting in there. It's cringe. Like I'm like, bro, what's wrong with you?
The part for me was,
like this.
Yeah, the part
Every
that's
time, like, what is wrong with you, man?
But the part for me, and I know Adams called it out before, but the part for me is like, because of that snafu with Law and Crime in the beginning that panned over, like, you're doing this in front of the jury. You're having these little side conversations in front of the jury. You're having tantrums in front of the jury. So you're even distracting them from what they're paying attention to, because they're looking at you. You're sitting right there in front of a camera for the public to see, and then right there for the jury to see.
And then Judge Glanville says he wishes you would have brought this to my attention sooner. Why does someone have to bring this to your attention? Like, you can see. And that's the same thing I say about everything that happened in the ex parte meeting, when people say, well, why didn't Kayla stop it? Or why didn't Kayla say it? Wasn't my duty to stop it. It was the judge's duty to stop it.
I'm about to say, what were you supposed to do with the judge sitting right there?
Yeah.
What were you supposed to do? Like, I don't, like, now hearing that, like, first of all, hey, Deputy Brown. Hey, Deputy Brown. Oh,
you know what I'm gonna do tomorrow when I go to court? I'm gonna be so scared. I'm gonna look him right in his face. Like, I ain't putting my phone in there though.
Listen, I said if they have to put Woody back on the stand, I'm catching the flight. I'm signing in, and I'm gonna speak to him too. Because if they make it that far, I just don't understand. Like, the scary part about all this is, like, I hate that it happened to you, because in that moment, public embarrassment is like, for what? And then you know who I am, you know my title, and then to add on top of that the anxiety of the things that have already happened outside of your control because you plan to help a friend out for a couple of hours. So, but it's just like, if it didn't happen to you, if it didn't happen to Thug, like, how will we know? How many more people would Deputy Brown take advantage of? How many people who are in shackles, who can say nothing, do nothing, and are at his mercy because they want him to be nice so they can have a decent kind of day before they go back to those conditions? How many of those do we not see? And then how many ex partes have there been where somebody was in it like that, felt uncomfortable, was like, well, the judge said it was cool? How many people have this happened to? Like, I don't know what was supposed to happen or what was not supposed to happen with this. I understand people were unalived. I understand things were happening. But at the end of the day, like I always say when I'm on the live, on the TikTok and stuff like that, like, this is any town, USA. This is any county. This is your county. Like, you're getting eyes to see this. And so when you elect these people and you vote, or you don't vote, you just go vote for the president and don't check anything else. Like, you put these people in place, and these people end up getting their people underneath them. And it's just like, if you have somebody that allows somebody to operate like that, or people like Deputy Brown that operate like that unchecked, people that throw tantrums are unprofessional, like Love, people that write a motion that's not quite right, but then somebody rules on it, that's somebody's life. That's somebody's life. And there's so many they're nameless because we don't know who they are, but I'm sure Fulton County and every other county jail is full of people who just needed a fair shake.
Yep. And
just needed a fair shake.
I have so many people contacting me now saying, and I don't think that there's merit to everyone, but I was done wrong by a deputy district attorney, Love. She did the same thing to me. I was done wrong by Judge Glanville. And it's hard as a defense attorney because, some people are taking advantage of the situation, but what about people who are telling the truth? It's like, you can't, it's hard.
It's really hard when you see stuff like what was happening to you today, or what's happening in there, or some of these meetings and what actually comes out and how long it takes to come out. If it comes out, now you have to think like, is it truth or is it not truth? And then for things that you want to throw off, like, yeah, everybody's not telling the truth, you're almost scared to say they're not because you don't know what's happening.
Yeah, well, okay, guys, I'm exhausted and I am going back to court tomorrow. I'm going to stand tall. I'm going to stand in my truth. Okay. I'm not going to let
Yes.
nobody have me scared or anything like that, because at the end of the day, I believe that you have to treat people right. And I treat people right. I do right by people. And I stood up for my part in the situation. So, I could have been threw him under the bus. I been knew what happened. But I chose to walk with integrity and just mind my business. But today you decided not to mind your business.
You
And
decided to treat people.
And it was
like
embarrassing. It was very embarrassing, because it's like like I said, everything is already like Kayla's here, it's tense.
Right.
People looking at the district attorney's office looking at me cry, which I don't care about, but bro, why you want to bring additional attention to me?
And what am I going to show somebody? Like, why would I come in here and show somebody my phone?
I was on my email. I was ordering. I'm going to Brazil. I was doing a Fashion Nova order.
Listen, worried about what I'm doing. I'm trying to get my vacation on. Like, just go on about your business.
But showing somebody something in my phone
during that, and my thing is, you knew
everybody was trying to listen.
You knew who I was when I came in there, and you just chose to make an issue like that. Just like my grandmother used to say,
just did you a favor.
That like just did you and asked for a favor. That's the crazy part. You asked for a favor and then try to put me up out of here and give me a problem. Like, why would you? He's scared with you around. He's intimidated with you around because he know you know.
Yeah, I know. But at the end, it wasn't nothing. I never had a problem with him. My whole thing is, as a man, and this is why I say this. This is why, but people can believe what they want to believe about me and Woody. But I say this, and I don't say it lightly. As a man, he did what he was supposed to do in that situation. And he did everything he could do to protect me. He knew I needed to get to my children. He knew that I didn't have nothing to do with what was going on. And as a man, he stood up for me. And he told them multiple times, play with her if y'all want to. And I know he meant it. And all I'm saying is, like, and that means a lot to me, because we did not have a real relationship. Like, I had represented him before or whatever, but we did not have a friendship. Now we have developed a friendship because nobody knows what happened in that room except for, me, him, the people that was in there, and Deputy Brown, of course. But, I mean, the amount of pressure was on both of us. And like I said, I was almost going to have a mental breakdown when I walked out of that room. And all of this was in hindsight. But he stood up for me. He protected me. And my whole thing is with that man is, you knew what you had done, which wasn't wrong. And you had way less to lose than me. Why would you have been fired for that? It wasn't a confidential meeting. Why would you get in trouble? But you see this man going on and on. And instead of standing up for what you did, you coward. You can't look at me.
And sat there and watched, though. And sat there and watched while somebody else, a woman, is being blamed for it. Everybody knew what Glanville was implying from the beginning to the end. The whole show cause, like, you heard all of that. And you, like, he would have let that show cause happen, and he'd have stood there. He'd have stood there and let anything happen to you. And see, that just, I always go by karma visits your intentions, not your actions. So what was your intention when you went and gave that information? Why did you pick Steele to give that information to? Like, there was a whole nother intention because of that. And because of that, that's why Thugger Daily just shouted you out, Deputy Brown. That's why.
And I'm gonna say this: I can't confirm that he told Steele direct. I don't know who he told. You know what I'm saying? I don't know how that unfolded, but the energy was off immediately. I'm telling you, like, immediately off. And I'm like, bro, what's up with you?
Like, what's your problem? And then you just, oh yeah. I kept saying that though. I kept saying it. It was a deputy. It was a deputy. And everybody was like, no, it was this person. I'm like, no, I knew it wasn't you. I knew it wasn't you. I was like, she was up there with them. And then it's a whole like half hour where y'all were off the record. I'm like, she was with Wooly. Like there was nothing that
It
she
wasn't
couldn't
a
have made it
chance.
back down there.
It was no opportunity. It happened so quick. And like I said, I can't sit here and honestly say that I would not have told, but I just didn't get a chance to.
But they didn't, nowhere in that transcript does it say, hey, Pinky promise, swear, put your hand on the Bible. Nobody ever speak of this after we leave this room. Like nobody said this was a that type of meeting, which again is so scary to me because knowing the lie that y'all told to get that man to testify in that room without telling nobody, you better not tell. Y'all done this before.
Y'all, it was too easy.
Y'all did this before. This is not new. That's the only thing I said. I said the only reason why this was different is because Kayla was in there. That's the only reason. That's why they had to blame. And that will be the only reason why they would jump and blame it on you. She's the only outsider. She's the only one that don't know how this works.
Outsider.
She's the only one
that
hasn't been
here.
She hasn't been here. She don't know how it works. It had to be her. See? Ooh, Glanville. You and that dog better apologize, Glanville.
And the only reason I even said something is because not necessarily about him, but it was about Glanville. I let Glanville ride with it. I never tried to correct it or no, but I'm just, people finna stop playing with me.
It's just I'm not the one or the two. Don't play with me, and I see you tomorrow.
And don't call me if you got a case in Fulton County. You don't want me to be your lawyer no more.
They're gonna be mad.
They're gonna be mad at me. Okay, thank you so much, Miss Jefferson. I dropped your link in the chat. Y'all make sure y'all go follow her on YouTube, on TikTok, on everything. I appreciate you guys. We did good. We kept 1,000 people on here all night. Shout out to y'all. Thank you so much. I will see you guys tomorrow. I'll let you know what happens in court. We'll do some Hallway Chronicles.
All right, y'all. It's been real.
I'm gonna get on TikTok for a little while, so I'll see if y'all want to come over there. I'm gonna get on there for a second.
Okay.
All right. Bye. Thank y'all so much.